What a difference a week makes. Bryan Kohberger and his case moved to Boise, Idaho.
But does that even mean anything? In a shocking change of events, the Kohberger case has been moved. I'm Lainey Law.
And I'm attorney Andrew Myers.
And I hate to say I was wrong because I didn't think it would happen, but it looks like it finally happened. The case has been moved. So I think a lot of people, well, depending on what side of the fence you are, I was going to say be happy or upset about that. But I think that it was a fair decision to make. I think that when you live in a town with such a crazy thing happening in it, you are going to be biased. So reasonable.
A lot of people thought that Judge John Judge would want to hold his grasp onto that case. And there have been allegations that Judge Judge and the prosecutor, William Thompson, were tight and that they wanted to hold on to that case. But as we'll talk about in a little bit, I think Thompson kind of backed away from the case. And I think the judge, well, let's take a look at exactly what the final ruling was. We'll look at the judge's determination, but after the judge kind of played volleyball and threw the thing into the other side of the court, the Supreme Court of Idaho issued this order. An order granting defendants' motion to change venue was entered in the district court, wherein it was requested that venue for trial be transferred from Latah County, 2nd Judicial District, in the case listed below. And there it is, State of Idaho versus Bryan Kohberger. Therefore, after due consideration and good cause appearing, it is ordered that venue for all further proceedings in this case are transferred from Latah County, 2nd Judicial District, to Ada County, 4th Judicial District. That's in Boise. It is further ordered that District Judge Stephen Hippler shall be assigned to this case and may not be disqualified without cause pursuant to the rule in Idaho. And you would think that the Idaho Supreme Court probably vetted this judge out, but they're just saying that in case there's some unknown conflict of interest. The point being, however, the John Judge is no longer in the case.
That has my jaw on the ground. I did not think this day would come. I did not think that was going to happen. I did not think that he would let this case go. Now, for people watching, if he wanted to, would Judge have been able to follow this case to the new county?
That's a possibility. Yes, that was a possibility, but a lot of people speculated about that, the way the order by Judge was worded, and we're going to look at that in a minute, but that wasn't to be. That wasn't to be. You gotta question what's behind all of this. Let's finish reading this, though. It's further ordered that the defendant shall be transferred forthwith to the custody of the Ada County Sheriff pursuant to Idaho Code Section 19805. So not only the case, but Mr. Kohberger also, boom, out of Moscow. And it's further ordered that the district court clerk for Latah County shall file and serve this order upon the parties or their counsel and take any action necessary to transfer venue of this case to Ada County. So that's it. They moved. Remember when Chief Fry drove up to 1122 King Road with a U-Haul and took stuff out of there? Well, the whole case is now being moved, not necessarily in a U-Haul, but the case is out of Moscow. No more 2nd District Court, no more Judge John Judge. And we have to question what else is going to happen with the future of this case.
I'm curious to see how this is going to impact things coming out, because this is a huge development. I mean, I was really under the impression that there was no chance that it was getting moved. And if you had the court case originally in Moscow, that people are going to be traumatized from the events, and they're going to, like we talked about before, they're going to need to believe that he's guilty in order to sleep at night. So now having it actually moved, this is opening up a whole new realm of possibilities. I mean, ultimately, what evidence we have is not going to change, and we don't know what evidence is going to be presented. But I think this is huge.
Well, it is huge, but in my view, there was no other decision to be made. There was no other decision to be made, and here's why. Here's page 16 of the order granting defendants' motion to change venue. And this, by the way, was written by Judge Judge. considering the undisputed evidence presented by the defense, the extreme nature of the news coverage in this case, and the smaller population in Latah County, the defense has met the rather low standard of demonstrating a reasonable likelihood that a prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. The reason I made these few words in a different highlighted color, undisputed evidence.
Undisputed is crazy.
You know, I mean, the defense attorneys presented 5 experts, and we sat through a very long day of testimony where the experts went on the stand. The prime expert, well, I shouldn't say prime because they all had very important things to say, but Brian Edelman had done a very extensive survey of people in different counties, including Ada County and including Latah County. Went into an extensive amount of depth on the feelings and thoughts of the potential jurors and what they'd been exposed to and what their thoughts were, what their biases were. At the end of it, no cross-examination by the state, by William Thompson. And yes, I got a couple of comments. Oh, well, he didn't have to do it. It was so thorough. He didn't have. Well, you know what? Any trial attorney worth his salt who's taken trial skills 101 in law school can cross-examine anyone. I mean, even if you're sitting in court defending someone and the prosecution comes through and just has a bada bing, bada boom element, 1, 2, 3, 4, open and shut, sealed case. No. Any trial attorney worth his salt can conduct a cross-examination. Well, what does this mean? Isn't it true that it doesn't really mean that? Isn't it true that you didn't really observe this? And what were the distances? The distances weren't. My point is, I think that the prosecution is kind of walking away from the case where there was undisputed evidence presented by the case. I mean, remember when they were talking about the surveys in the very beginning? Apparently Edelman's company was conducting this research and calling people, and people were calling the prosecution, and the prosecutor, Mr. Thompson, immediately objected and wanted an immediate hearing to stop all of this. And we have to stop these surveys. This is tainting the jury. So then they have the hearing, and what does Mr. Thompson do in open court? On YouTube, which is worldwide, he starts reading these questions that he said were tainting the jury. So that was one issue. And then he doesn't even really make yes, they filed a perfunctory objection and they did make an argument at the close of the hearing. But I just wonder if the prosecutors in Latah County are just kind of walking away from this.
Yeah, with how it says the undisputed, that you do make a good point with that, in that there was no fighting it. And when I hear the word undisputed, that doesn't, I normally don't think about it in the legal sense, because when I think undisputed, it's just like, oh, well, the judge is agreeing with the defense. But that's really, I don't really want to say a jab at the prosecution, but it almost feels like it to a level where it's kind of addressing the point that they never really had a counter argument for it.
No.
I understand, with judge moving the trial, giving it to someone else. Oh my God, it's been such a whirlwind. And, obviously he has a duty to the state and he has a duty to the court, but oh my gosh, is probably sleeping well tonight.
Well, I hate to say it, but I think this court was in over its head. You can go on the docket. You can go in that Second Judicial District, Latah County Court, and look at their docket. And both the court itself and the prosecutor, Mr. Thompson, have a ton of cases. They both have a ton of cases, and they're the type of thing that you could expect in a university town. I said before, I lived in a university town for a while, and, hate to say it, but drinking complaints, noise complaints, dog complaints, drunk driving complaints, other motor vehicle complaints, they fill the docket. And I checked the Second Judicial District, Latah County, Moscow Court, and their docket is full. Their docket is really very full. So it just seemed from the start that And you look at the judge during some of these hearings that we've been able to watch on Zoom through YouTube, the judge's channel, and he looks befuddled. He said himself that this, after the hearing on the motion to change venue, he said himself, this is the most difficult decision I've ever had to make. And then he made the decision within days. So the other thing that kind of stood out to me was that this rises to constitutional proportions. Does the guy get a fair trial? Whether you think that Bryan Kohberger is guilty as the day is long, and I know there are people like that in the world and in our comment section, or whether you think that he's innocent, makes no difference what you think. This rises to constitutional proportions. Any defendant who is charged with a crime is entitled to a presumption of innocence and a fair trial. Those are really basic rights in our Constitution. And yet the judge goes on and on and on to say how inconvenient it would have been to have the trial in Latah County. The Latah County Sheriff's Office, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial, while also continuing to perform their day-to-day duties of patrol and responding to calls. While our local law enforcement is ready and willing to do what they need to do to ensure a safe trial, there are not enough officers to ensure the safety of the parties, witnesses, victims, families, jurors, and a community for a 3-month period. While the state has a dedicated space within the courthouse, the state would still be faced with the challenge of escorting sensitive witnesses through public spaces in the courthouse to get to the courtroom. Meanwhile, the defense does not have a dedicated space within the courthouse, and there are limited options available. And so this decision goes on and on and on about how inconvenient it would have been, and that the Latah County, it's a tiny little county, would have been unable to really host the trial. Well, if that's true, why didn't they move it ages ago? Why have they been fiddling around with it for 1.5 years, not quite 2 years? It's just, so that part of this decision made no sense to me. It's almost like the bootstrap, because the only argument that's really valid, and yes, I've read the rule that says, for the convenience of the parties and that kind of thing. I've read the rule. You can scold me down in the comments as you always do. But the fact is, this is a constitutional issue. And so to go on and on and on about how the court just isn't able to, it's almost like having the Rolling Stones down at the local firehouse.
Well, and I wonder too how we've been kind of going. I mean, how long have we been talking about this case, guys, realistically? And that's just our channel. That's, not even thinking about people before that. But it's just like, it's almost, and I agree that the other location is better suited to take care of this situation. It's like they had to go through like 1.5 years of getting berated by the public and all of this stuff, and Judge finally was just like, you know what, like, get it out of here. We haven't been able to handle it. The town is going to be in disarray the parking situation. They couldn't even figure out parking, much less how they were going to transport the jurors in and out and stuff like that. So I understand why the decision is made. I just imagine that Judge has thousands and thousands of emails flooding his inbox and is, maybe relieved to get this out of there. But this is also at least going to be a lot better for the town itself, because how on earth was the town going to recover even in this situation outside of the court, where everybody and their mother is coming from all over the universe to crowd around Moscow because the case is going to happen there.
Yeah, that court just wasn't really geared up either, by the normal daily machinations of the court, or the fact that that building is also the municipal building and has other municipal offices in it across the street from the school. I fear that I've dated myself by saying it's kind of like having the Rolling Stones play in the local firehouse, so I'll update it. It's having this trial in the Latah County, Moscow 2nd District Court is kind of like having Taylor Swift perform at the local bingo hall.
I'll be there.
I'm sure you will. I'll watch it on TV. Anyhow, this is the conclusion of the actual order to change venue. And as you can see, it was signed off by Judge. Kohberger's motion to change venue is granted pursuant to Idaho Criminal Rule 21A and 21B. consistent with the language of Idaho Criminal Rule 21C2B, this court orders a transfer of venue without specifying the new place of venue and refers the case to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another judicial district, and assignment of a specific judge to preside in the criminal proceeding. So now some people read into that, well, maybe he could have been the one that was assigned. But I kind of think just the way that he wrote this, assignment of a specific judge to preside in the criminal proceeding, I read that to say, and you can disagree with me in the comments, that's okay. I read that to say he not only wanted a different court, but another specific judge. I think that while there was enough wiggle room that he could have been appointed, I tend to think a phone call was made and he said, look, guys, no, I don't want this anymore. That's my opinion. I just think that he wanted out of the case. I think the heat had been on for too long. It was too much. Non-dissemination order, the media, throwing the media out. I think he was probably sick of the media, just hammering him, disobeying his orders. The prosecutor, William Thompson, at times tended to scold people. I don't think that he liked that. And so I think he wanted out of it. And I think he made the right decision. I really think I know there are people out there that totally disagree with that. Some of the families have said, and they have a right to comment, absolutely. Some of the families have said, this is very inconvenient for us. We're going to have to go, 300-400 miles south. And I do understand how they feel about it. I mean, they have every right to go and attend and watch and see what's going on. And I know people will disagree with me, but the constitutional requirement, the fundamental requirement of having a fair trial overrides all of that. I'm sorry, it just does. That's the way our judicial system is set up. The victims, absolutely, the victims' families absolutely have rights. The victims' families absolutely should be taken into consideration. But in consideration of the victims' feelings and thoughts, in my opinion, it's better to get the trial somewhere else, because a really significant point is that had the trial gone forward and had Mr. Kohberger been convicted, he would have had an automatic appeal based on all of the evidence that Ann Taylor and that crew put in about how prejudiced that whole community was. Not only that there had been a lot of publicity, but that from the very start, people just tended to believe what law enforcement said. If law enforcement said, we've got the right guy, and if law enforcement said, oh, trust us, from the very beginning, and if people that were surveyed said, we're going to burn down the courthouse, and worse, I mean, it sounded like there was a mob mentality. So had Mr. Kohberger been convicted, there would have been an automatic appeal for good grounds, for very good grounds. So I think the victims' families, again, I have a lot of feelings for them. I do have, a lot of understanding for them and compassion for them, but this was the right decision to be made legally, practically, and in a lot of other ways. So now the next question is, will Bill Thompson remain on the case? I mean, he's the local prosecutor. There's no
way they're going to make him drive all that way, though. Is there? I honestly, as crazy as it would be, it would be interesting to see the state come up with another prosecutor, but he's already so deeply involved with this case.
Well, I had to dig it out of my notes. But here they are. If you've noticed in the most recent pleadings, two attorneys from the Idaho Attorney General's office have been in on most of the pleadings in this case. The Assistant Attorney General Jeffrey Nye has been in this case from the start, as has been Attorney General Assistant Ingrid Beatty, and their offices are down in Boise. So, I mean, does this give Bill Thompson an out? Does he want to go down and try the case when there have already been a couple of attorney generals signing off on the pleadings? I mean, that's an open question. That's really an open question. So, all we can do is see what's going on in the case. I think Thompson has taken more of a back seat than he did earlier for the reasons I stated before. I think he may or may not want to back out of the case. We'll see. I don't know. And I think maybe Judge had some issues. I think Judge finally came to the realization that he had some issues in this case. Remember the whole dispute over the investigative genetic genealogy?
Mm-hmm.
They were fighting over that, and the prosecution said, we don't want to give it out because we're not going to use it at trial, and so we're not going to disclose it. And pages and pages and pages and pages of pleadings were filed, and Ann Taylor finally convinced the judge to look at it in camera, as they say. What that means is the judge looks at it by himself in his office. And then he decided what would be shown to the defense. Well, wait a minute. That means that the judge has more knowledge about an issue than the defense.
Mm-hmm.
So that not only did the prosecution want to withhold evidence, but also the judge knew what was being withheld, and he didn't want the defense to know about it. So remember what just happened in the Alec Baldwin trial, where in the middle of the trial, it came out that the prosecution had withheld evidence? Immediate mistrial. So that and some other things make me wonder whether Judge realized that it was time for him to move along.
Are you sure it wasn't the fact that he was trying to stream it or do whatever on YouTube from your personal experience like a year ago when I came in? You don't think he made one too many YouTube streams and then finally snapped on top of all of the pressure from his regular job?
I don't know.
For everybody that wants to complain about us coming here every week, that doesn't know how much effort goes in behind the scenes.
Well, I assume, without knowing, that Judge had a court staff. Every court I've ever been in has a reasonably sized staff, except for the little ones out in the little towns. But even there's someone. So I have to assume that he had someone to set things up for him. So I doubt if that was a reason. But you raise an interesting point. What's the future of broadcasting or streaming the trials? There's a little bit of precedent in that Lori Vallow and Chad Daybell were both tried in that courthouse in Boise, the Ada County courthouse. And at least in the Chad Daybell trial, that was streamed. I watched a fair amount of it. It was streamed. It was similar to what Judge did. It wasn't the best coverage. It would be better if one of the networks were allowed in to do their professional broadcasters, have ways of making sure the lighting and the sound and everything. But so my guess is that things will be done pretty much the same way as they were in the recent Chad Daybell trial. So there will be coverage. That's an issue that I'm sure will be resolved at some point. So
the coverage, the whole, thank goodness for YouTube, or else you guys wouldn't be watching this right now. But also at the same time, it's good that the cases are being streamed to YouTube, because obviously we want a way that's accessible and free for everybody. Not everybody has cable TV. Not everybody has internet either. But I also think it's weird too to be putting legal proceedings on YouTube. I think it's good to put them on YouTube, but the court needs to have, like you said, letting the media in or having some type of standard to do this. It's so hard when you have all these 50 states have their own different rules. But I don't really I'm with everything that involves government. Obviously, it's a slow and arduous journey, but there really should be some type of, and maybe there is a database that's directly hosted on whether it's Idaho's site or just any navigation system that has these videos and these streamings, because it's weird that it's on YouTube. I think there should be a free way to access it, but I don't know.
Well, a lot of the courts do that, and it's what we came to understand was happening in this case, and so that's how they do it in Idaho.
So are there any other little tidbits sneaking in this document that you have here?
Well, do you remember the whole issue about how the university was kind of a little bit too close to the investigation? Remember all that in Scott Green's book, how he said that he were at the initial meetings of law enforcement twice a day? Well, I found it interesting that Scott Green reemerged in this order granting the defendant's motion to change venue. Look at this. The former Moscow Police Department Chief James Fry, who was the police chief during the investigation into the homicides, publicly declared he had no doubts that the right guy had been arrested for the crimes. After Kohberger's arrest, the University of Idaho President Scott Green stated publicly that the university community once again felt safe. Generally speaking, individuals are more likely to trust and believe authority figures. So these statements by Latah County authority figures are particularly impactful to Latah County residents. So there's Green again. Green's been in from the very beginning when he met with the law enforcement twice a day to now when the venue's finally, leaving, Green's there to say goodbye. And it's like he's cited as an authority figure. Look at that. He is cited as one of the authority figures that has been in on this case.
I want to make a joke about his book sales, but I'm sure any book sales to him are good book sales. The fact that, he's selling the book at all. But I think it's a really valid point. I think that whether it's, university faculty in this college town or the police officers, especially because the police officers talked about how they were over there 1.5 million times a day. So I think that the fact to specify that Green's involvement could contribute to the bias, I think is really important because you have someone who's allegedly in regular conversations with law enforcement saying everything's good, go back to normal, guys. And it is crazy too to be saying all of that stuff because we talk about it every single day on this channel where you can't just do that. You can't just say that's the guy because then what happens in court if it comes out that he's innocent for whatever reason or another?
That's one of the reasons that's one of the reasons venue was changed was because the police chief came right out and said he's the right guy, and people, right or wrong, people tend to believe authority figures as well. In some circumstances maybe they should, but because of that much deference to authority and because of that much emphatic focus on Kohberger being quote unquote the right guy. And for the university president, where so many people in that community have some kind of association with the university, be a part of that and to be called an authority figure, it's just something a little bit unseemly about the whole thing. I don't know. So I think the judge made the right decision. I think he knows he made the right decision for the reasons we stated. And I think, in a way, I'm thinking the judge is breathing a sigh of relief.
Yeah. Oh my God. I don't want to make it too much about him and his own personal life because obviously he has a duty to the court, but I can't imagine, just living my life. I want to be an attorney one day. You go, you work your way up and you get voted to be a judge. And then, you're just living your life, dealing with the DWIs, dealing with, like the noise complaints and all the pet things that you were talking about earlier. And now the entire world is hyper focused on your court. With the access of internet, I can't imagine, like, people are probably going to his house and stuff. That's everybody in this court case. Everybody, whether it be like even the Idaho 4, we talk about those poor victims, the remaining roommates, where their lives are probably completely inundated by people online. If you're watching this, don't go harass anyone, please. But, Judge John Judge is probably sitting in his chair with the Bud Light right now, being like, "Oh my God, it's finally over." I don't know, I can't imagine anybody, you're just trying to do your job, and then all of a sudden it's a national headline. It's crazy, and
if you're a judge and you're specially assigned to one case, and that's the only case you deal with, that's one thing. But if you're a district court judge and you deal with the volume of stuff that I saw in the docket of that case, and then you're assigned to a case like this, you can't be perfect. You can't be perfect. And it's just, so let us know down in the comments what you think is going to happen with this case. is the case going to go on June 2nd, as had been specified in the scheduling order? I mean, remember, a scheduling order came out just a couple of months ago, and the trial was set for June 2nd of 2025. And people said, oh, yeah, even if it goes to another court, it'll stay there. But no, if a new judge comes in, my guess, and I don't have a crystal ball, but my guess is this judge is going to have a status conference pretty soon where he's going to call the attorneys in and say, hey, what is this with the IGG? Hey, what is this with all these other issues? What is this with 17 rounds of discovery, and there's never been a motion to compel that's been allowed? What's going on here? So that's my guess. My guess is we're going to see some interesting developments in this case, and that's as far as I'll go. But how is it that this case has just been sitting there and sitting there and sitting there and rolling along, and we really don't have a lot of facts from the initial non-dissemination order, which I've said before, I think sealed the goose on this case because it made more of a problem than it should have. I mean, had they released some information, had they released some facts, you wouldn't have 1,000 million billion people, not me, on YouTube talking about the case every day. So my guess is that we're going to see some interesting developments. I think the judge early on will have a status conference with the participants. Whether it's open or not remains to be seen. But, the judge is going to rein things in, say, hey, what's going on? What's with all these issues? So who knows whether it'll go on June 2nd of 2025. I guess we'll find out, won't we?
Oh my God, June 2nd. That seems so far away. But now you mentioned the non-dissemination. I want to bring that back up quickly. There's no way that anything's changing with that, right? He's probably just going to respect Judge's ruling.
It's hard to say because a lot of people, not just me, a lot of people think that the non-dissemination order went too far. Yes, there's such a thing as integrity of an investigation. And yes, there's such a thing as the prosecution being able to hold on to certain facts until trial. And that, yes, that does happen in every case. But it really locked things down a little bit more than you usually see in a case. And I bet that it will be revisited. I mean, remember, both the defense and the prosecution in this case agreed to the non-dissemination order. But there's no reason why in an early status conference, the judge can't say, do you think we can relax it a little bit? Do you think we can talk a little bit more? I mean, the public does, in fact, I get in trouble every time I say this, but the public does have a right to know. See the Nebraska Press Association case, which says, yes, there's a Sixth Amendment right to a fair trial, but yes, there is a public right to know, and they have to be balanced. And here's how you do it. And we talked about that in a previous episode. So that's a long-winded answer to say, I think it'll be revisited. Whether it changes or not, I really don't know. I can't say.
Yeah, it's hard because, like you said, the prosecution and the defense both agreed to it. But at the same time, it's a big portion as to why we have this national hysteria. So who's to say? Whew, what an episode.
Okay. Thanks for joining us. Let us know what your comments are on this case and others. And I guess it's time for the grocery store. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.